Medical Board of California. Today's date, April 19th, 2018. And we would like to call this meeting to order. Thank you.
Okay. Ms. Lawson? Dr. Bolat?
Here.
Dr. Gonadev?
Here.
Dr. Krause?
Present.
Dr. Levine?
Here.
Ms. Pines? Here. We have a quorum.
Thank you. I would like to introduce our Judge Perlman, who will be presiding over these sessions. And with this, I will turn it over to her for our next oral argument and before we begin.
Thank you very much. So we are on the record before the Medical Board of California in the matter of the accusation against Dennis Stolpner, MD, Medical Board number 800-2016-025732, OAH case number 2018-031-246. As was indicated, I'm Lori Perlman. I'm an administrative law judge with the Office of Administrative Hearings, and I've been asked to preside over this hearing this morning. We did have the panel members identify themselves for the record, and I am told that we do have a quorum this morning. So that being accomplished, I will now take the appearance of counsel. I'll start first with the Deputy Attorney General.
Good morning, Your Honor, members of the board. My name is David Carr, Deputy Attorney General, representing complainant in this matter.
And could you spell your name for the record, please?
It is C-A-R-R.
Thank you, Mr. Carr. And then for respondent?
Good morning, Judge Perlman and members of the board. My name is Peter Osinoff, spelled O-S-I-N-O-F-F.
Thank you. And do I see that you have Dr. Stolpner with you?
I have the privilege of having Dr. Stolpner on my left. Thank you.
Good morning to you as well. Okay, so the board in this matter has issued an order of non-adoption of a proposed decision by an administrative law judge and has decided to determine the matter itself upon the record, including transcript and exhibits and written and oral argument. And we will have discussion this morning in regard to that. If I am understanding correctly, the process will be as follows. Respondent will have 15 minutes to make an opening argument. Complainant will have 15 minutes for a response. Respondent will then have 5 minutes for closing, and complainant will have 5 minutes for closing as well. Is that everyone's understanding of what was intended? Very good. And we will have to strictly enforce these time limits. As I'm sure you're aware, the arguments have to be based on the existing record, cannot exceed the scope of the record of duly admitted evidence, and no new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that would elicit new evidence. The ALJ and any panel member may ask a party to support the party's oral argument on a matter with a specific citation to the record. At the end of the oral arguments by counsel, I'll offer the respondent physician an opportunity to address the panel regarding the matter. If the respondent elects to address the panel, I will place Dr. Stolpner under oath. After oral argument, the board will go into closed session to deliberate. The parties will not receive a decision today, but will be receiving it in the mail in the future. And the board has already had the benefit of considering this matter and reviewing what has been submitted. And with that, I will now turn to respondent to make an opening argument.
Thank you, Judge Perlman.
Sorry, Your Honor.
Yes.
Can I have you actually put the mic, bend it down for you?
Is
Thank
that
you.
better?
Yes, thank you, Counsel.
Oh, okay, that's no problem. Sometimes I think my voice is loud enough, but it is my privilege to speak on behalf of Dr. Stolpner in this licensing matter, wherein the administrative law judge issued a probationary license to Dr. Stolpner. Now, who is Dennis Stolpner? and I refer to him as a doctor because he is a physician licensed without restriction in the state of New York for the past 5 years and in the state of Florida for the past 3 years. His family lives in California, and he wants to practice medicine here. He is a man of science, having graduated from University of California at Berkeley with honors in molecular and cell biology, and he's a person with great caring and compassion for others. He received glowing evaluations from his deans at New York Medical College, who described him as, quote, very bright, committed, and mature, with consistently exceptional performance in general surgery, and, quote, throughout all of his clinical assignments, he has earned substantial praise for his enthusiasm, dedication, professionalism, fine work ethic, team spirit, and impressive learning attitude. He also has exemplary interpersonal skills and wonderful humanistic qualities. That's in Exhibit F at page 5. During college and medical school, he was the Los Angeles Regional Coordinator for the Department of Chernobyl Recovery, calling attention to a disaster which had dramatically impacted the people in his native country of Belarus. While in school, he did research both at Cedars-Sinai here in Los Angeles and at UCLA that resulted in publications, and he volunteered at the Los Angeles Free Clinic and at the Mattel Children's Hospital. Since his termination from the 3rd year of his OBGYN residency, he worked as a physician in a pediatric clinic in Argentina in 2016, and while there he intensively studied and learned Spanish, which prepared him to serve better a large portion of the California population. Last year, he volunteered his services as a physician in Guatemala. He studied more than 175 hours 2 years ago to become nationally certified as an EMT. Last year, he put that training as an EMT to good use in Houston after Hurricane Harvey, where he volunteered his services. He also recertified in basic life support and in ACLS. Also last year, he worked as an MA, medical assistant, in offices at Olympia Medical Center and received letters of support, which are found in Exhibits EE and II, from physicians whom he shadowed and with whom he discussed cases, and I'll quote, demonstrating a strong knowledge base in medicine, specifically endocrinology, rheumatology, and cardiopulmonary disorders. That's at Exhibit EE. The physicians noted that he was able to communicate both in Russian and in Spanish with patients in their native tongues. He was said to be kind, compassionate, respectful, and understood cultural nuances. He's the kind of person that we would want as a physician in California. So why deny a license to a person like Dr. Stolpner? 3 grounds have been advanced by the Attorney General's office, but basically there is only one advanced. There's really a ground for denial of a license, and that is the ground of incompetence because he couldn't complete his 3rd year of his OBGYN residency at Lutheran Medical Center in New York. The other 2 grounds are not argued as grounds for denial, but they are grounds for consideration. And the other 2 are that he had a DUI 6.5 years ago, and the 3rd ground is that he was grossly negligent in denying that his DUI case was pending when applying for licensure in New York 5 years ago, resulting in a reprimand from the state of New York. I'll address each of these points. First, the ALJ found correctly that there was no incompetence as a physician as a matter of fact and law shown in this case. She found that the failure to complete the 3rd year in OBGYN residency doesn't mean that Dr. Stolpner is incompetent to practice medicine. Of course, licensure requires completion of at least 1 year of postgraduate training at an ACGME-approved program with at least 4 months of general medicine. I had it wrong in the brief. I'm sorry if I said 2 years, but throughout the whole case, other than that, it was 1 year. 2 years for foreign medical grads, but he's not. Dr. Stolpner completed 3 years of postgraduate training. 1 year at UC Davis, in a pre-surgical residency, and he was invited to proceed with the surgical residency, but he wanted to go into OBGYN, and so he transferred and spent 1 year at SUNY Downstate, State University of New York, Downstate Long Island College Hospital in OBGYN, another internship or first-year residency there. He then transferred because that institution, SUNY Downstate, was losing its accreditation. He transferred to Lutheran Medical Center for the second year of OBGYN residency, which he also completed. He passed all 3 steps of his USMLE. He more than met the minimum qualifications for licensure, having had 3 years in which he passed postgraduate. That was the testimony of the only expert witness at the hearing, Dr. Richard Johnson, who has been on the faculty at UCLA for 24 years, 21 of those years having been involved in the residency program and serving 6 years as the residency program director in family practice.
Could you spell the expert's name for the record?
Sure. Richard Johnson, or Johnson, Johnsson.
Thank you.
Dr. Johnson testified that becoming a specialist in OBGYN is different than becoming a physician and being licensed as a physician. Board certification or completion of a residency has never been required in this state or in any other state that I know of. There is no evidence in this case of any egregious behavior or egregious unprofessional behavior. There is no medical record or testimony that shows incompetence as a physician. Not having the independent clinical thinking and clinical judgment required of a PGY3, a third-year resident in OBGYN, in a particular residency program at Lutheran Medical Center in New York doesn't determine the competency of a physician. The Attorney General's office introduced a few poor faculty evaluations, and that can be found in Exhibit 10. This is Exhibit 10 in the record. We introduced evidence at Lutheran Medical Center of many more satisfactory or better evaluations. So there is not a one-sided negative review of Dr. Stolpner in this case. Now, the program director himself, at the end of the second postgraduate year, which is actually Dr. Stolpner's third postgraduate year, counting the one at Davis, rated his performance satisfactory in 7 out of 7 categories by the conclusion of that year. Even in his third year, which he didn't, the one he didn't complete, the one he was terminated from, he was assessed at the PGY 3 level or better in half of the 28 categories in which he was assessed. In another 11 categories, he was assessed at between level 2 and 3, and in the 3 remaining categories, he was assessed at a second-year residency level, which would be plenty for licensure. This is found at Exhibit N, pages 4 to 12. One of his faculty members from SUNY Downstate wrote a letter of support for him in glowing terms, noting his excellent fund of knowledge in OBGYN and that he is an adept surgeon and a caring physician, very hardworking and thorough. He was briefly placed on probation toward the end of that year, but he passed that year after improving his CREOG scores quite a bit. It was said by that physician at SUNY Downstate that, quote, he works well under pressure. That's in Exhibit FF. Another physician who helped train him at SUNY also wrote a letter of support in Exhibit JJ at page 10. Even a physician at Lutheran Medical Center at JJ at page 11 wrote a letter of support during his second postgraduate year there. The language in his residency termination letter suggesting that he, quote, should consider opportunities in a non-acute clinical setting it's Exhibit P, has been seized upon by the Attorney General's office to argue that it's unsafe to license Dr. Stolpner in California because there's no way to prevent him from practicing in an acute setting. I agree that all physicians work in acute settings at least from time to time, but Dr. Stolpner, remember, was said to work well under pressure, and since his residency he became certified as an EMT nationally, so he can and has functioned in acute settings. The most that can be concluded from his termination is that Dr. Stolpner couldn't make it through his PGY 3 year in OBGYN in the Lutheran Medical Center residency program. Not that he can't handle any acute care cases, nor that he can't function in a hospital, but not in an OBGYN program through his 3rd year. When it licenses physicians, the board doesn't determine practice parameters for a physician. The profession determines those parameters. Dr. Stolpner is not going to be credentialed at any hospital as an OBGYN unless he completes a residency in that field. Likewise, he's not going to be permitted to perform neurosurgery or cardiothoracic surgery or any surgery. As a licensing body, this board doesn't involve itself in determining what privileges should or should not be granted to a physician. There is no basis in this case for imposing any restriction upon him, much less to deny his license, for not being allowed to complete his 3rd year of a residency program. Now, as to the DUI, that occurred 6.5 years ago on a weekend night, not in connection with work whatsoever. And even the Attorney General's office has acknowledged that Dr. Stolpner is simply not a substance-abusing physician. He complied with the first offender programs. The DUI was expunged. The evidence is that he drinks only very modestly and has had no problem before or since without any substance. For that matter, this was his only scrape with the law in his entire lifetime. So there's no reason to place his license on probation for a 6.5-year-old DUI. Not even New York disciplined him for his DUI. In New York, he was disciplined for not disclosing the pending DUI charge on his application for licensure to that board more than 5 years ago. The New York discipline was a reprimand. Dishonesty wasn't charged. He was charged with gross negligence in answering an application question. The ALJ was correct in that there is no evidence to support dishonesty in this case. New York discovered Dr. Stolpner's error on his application when Dr. Stolpner himself revealed his conviction on his license renewal application to New York. He also revealed his conviction on his applications to California and to Florida. He revealed his conviction to all of his employers. In fact, he revealed the DUI in answer to every question except for that one question in the New York application when he didn't have a conviction but when his license was pending.
You have 3 more minutes.
Thank you very much. There is no reason to deny a license in California on this basis, particularly when New York itself found that a reprimand was sufficient. A license denial or even probation would be purely punitive. It would be a mistake to deny Dr. Stolpner a license in this state. He has a great desire to practice here and would serve the people of this state well. The issuance of a license would also give him a chance to complete a residency program as he testified he very much desires to do. The issuance of a 5-year probationary license is unnecessary to protect the public in this case. He's maintained a deep knowledge of medicine during the past 2 years, taking many CME courses and shadowing other physicians. There's no evidence of any knowledge deficiency, even during the final year of his residency program. Knowledge was not at issue. If the board is concerned about Dr. Stolpner's limited practice history during the past 2 years, a 5-year probation is certainly not the basis for protecting the public. Instead, the board should issue a license with a clinical evaluation. We call it PACE for short, but something like that program. He would need to comply with the recommendations of the program, and that can be enforced without any probationary requirement, which would only serve as an impediment to his being accepted in any practice or training program. In fact, this board could issue an order that he gets a license, but as a precondition even to practice, a precondition to practice, he needs to successfully complete the clinical evaluation program after the license is issued. He is willing to do that, and that would be the appropriate resolution if this board has any concern about Dr. Stolpner's continuing ability at this point to enter the practice of medicine at this time. And thank you very much.
Thank you, Mr. Osinoff. Okay, Mr. Carr, now's your opportunity to respond.
I shall take that opportunity. Thank you, Your Honor. Members of the board, good morning. Thank you for hearing us today. Dr. Stolpner's counsel is correct that the fundamental and prime issue before the board today in not adopting this proposed decision is that of Dr. Stolpner's competency. Competency, as you're well aware, extends beyond the mere parameters of technical ability or knowledge and must include, of course, critical thinking and clinical judgment in the ability to safely discharge the responsibilities of a licensed physician in California. The administrative law judge, in rendering her decision, created an artificial distinction in order to find that Dr. Stolpner is appropriate for licensing in California, finding that his failings at 2 residency programs where his practice was most closely scrutinized in a setting approximating that, more closely approximating that of actual clinical practice, was deficient. The administrative law judge decided that that did not rise, in her terms, the failings demonstrated did not rise to the level of incompetency for discipline purposes. She also noted that the termination letter issued to Dr. Stolpner by his second OBGYN residency program at Lutheran Medical Center in New York does not state that he's incompetent to practice, quote, in her terms, general medicine, but recommends that he consider opportunities in a non-acute clinical setting where they proposed he may have more success. If California allowed a 2-tiered medical license, one of which was a lesser license that permitted limited amounts of practice in a structured, controlled, protected environment, then this level of competency, what the ALJ terms general medicine, might be appropriate. However, as you're well aware, that is not the situation in California. The license is a general license which is offered, which is bestowed upon clinicians who have demonstrated proficiency, skill, and knowledge to a degree to warrant confidence in their ability to safely practice. There is nothing that would restrict Dr. Stolpner from practicing in an acute setting. It's true he might not be accorded immediate privileges at some acute care hospital, but he could do outpatient surgical facility work. He could do any number of medical procedures that require a level of ability, knowledge, and judgment that Dr. Stolpner has not demonstrated and manifestly has failed to be able to demonstrate at 2 successive residency programs. That level of competence not being demonstrated, there's no reason to have confidence in Dr. Stolpner's ability, if given a license here, to practice medicine generally under all manner of situations. Dr. Stolpner's counsel suggests that 5 years is too long a period of time. I would suggest that if the board believes there is reason to believe that Dr. Stolpner may be an appropriate candidate under appropriate settings, that a 5-year period probation is the absolute minimum, not only because that is what is, I beg your pardon, what is recommended, required, mandated by the disciplinary guidelines, but because it is a reasonable and logical minimum that would allow a period of effective oversight and mentoring, particularly if the other aspects of the disciplinary guideline requirements are imposed. The ALJ did not require 2 additional conditions of probation that would be absolutely necessary to promote and foster Dr. Stolpner's successful practice of safe medicine in California. That is, that he pursue additional continuing medical education above the minimum required, and most essentially, that he be required to have a practice monitor, a physician who would be allowed to both mentor and oversee Dr. Stolpner's practice on a longer-term basis in order to provide that level of assurance for the board that would be necessary to know that Dr. Stolpner is practicing safely.
Do you have a suggestion of how long the practice monitor should be in place?
I would say a minimum of 3 years, and that would be contingent, of course, upon the successful reporting from the practice monitor that he is competently and safely practicing medicine in an environment that tests and determines his ability to practice in a wide variety of circumstances. The failure to impose those conditions leaves the public exposed. The disciplinary guidelines at a minimum require this when competency is questioned, even in a licensed practitioner who may have been practicing for years. When we have a physician who's not been practicing in California, that wager, that gamble, the risk entailed in giving him an unrestricted license is unwarranted. The necessary minimums are imposed because of the cumulative experience of the board in developing disciplinary guidelines over decades. And that minimum level not only establishes a meaningful precedent for the board, but is the logical and necessary minimum in order to ensure safe practice when competency is questioned. Dr. Stolpner's practice as an EMT, while admirable and worthwhile and relevant to the practice of medicine, is in no way equivalent or synonymous with the practice of a physician licensed to do all things physicians are allowed to do in California. I would suggest that if the board believes that Dr. Stolpner is an appropriate candidate, that at a minimum, the 5-year period of probation be required with all of the standard conditions. PACE, which again is an admirable program, but it is a snapshot. The clinical education program offered there or at any other, by any other entity, is a necessarily time-limited exposure to Dr. Stolpner. I would suggest that the more effective determinant after successful completion of PACE would be the practice monitor, a physician who is putting her or his own reputation and ability on the line in mentoring and overseeing Dr. Stolpner. Thank you.
Thank you. Okay, so Mr. Osinoff, you now have 5 minutes.
Thank you, Your Honor. Had Dr. Stolpner applied for licensure following his year at UC Davis, he would have been granted an unrestricted certificate, an unrestricted license by this board to practice medicine in this state. Had he applied after the second year at SUNY Downstate, he would have been granted an unrestricted license to practice in this state. Had he applied and left the residency after his second year of his OBGYN residency, he would have been granted an unrestricted license to practice in this state. It is not a ground for discipline that a doctor can't complete a certification, a residency program, or the third year of a residency program in particular. If a doctor went back and got training and couldn't do it, and fell flat on his or her face, then they wouldn't get a restricted license or be disciplined here in the state of California. So he had 3 years after which he could have been, and he was certified by Davis and by SUNY Downstate as competent and able to practice in this medicine for the purpose of licensure. He would have been able to practice without restriction of any type in this state. Now, there was no finding that he's an incompetent physician by even at Lutheran Medical Center following his third year. With regard to PACE, PACE, as you all know, makes recommendations as if they do get a snapshot, but they also make recommendations as to what doctors need to do. And we have all seen doctors who have been asked by PACE or recommended by PACE to enter certain programs or to be evaluated in certain ways. They make recommendations, and this board adopts those recommendations in the form of an order, and can do so, and orders the physician to do whatever PACE recommends. If this board has any concern, and again, our first line position is that there is no basis to issue any type of a restricted license in this case, since he passed through 3 times the amount of postgraduate training than is required. But if this board feels that, well, we just want to be sure because we just want to be sure, does he have enough medical skills and knowledge at this point to function as a physician? Make him go through PACE. Give him a license, order him into PACE, but a 5-year probation with other terms and conditions that present great impediments to a doctor, particularly one starting out and trying to get a job with someone else or trying to get into a residency program. A 5-year probation or any probation creates enormous impediments for physicians, and there's no reason to have a probationary order in this case. If this board he feels that he needs to be evaluated, PACE could do a very good job and can make the recommendations, and this this medical board can enforce that order by issuing an order to the physician to follow the recommendations of PACE at this point. Thank you very much.
Thank you, Mr. Ostinoff. Mr. Carr, was this a statement of issues and not an accusation? Yes. Okay, I need to correct, at the beginning, I believe I said accusation. Let me correct that. This is a statement of issues. Okay, Mr. Carr, whenever you're ready, you have 5 minutes.
Thank you very much. Members of the board, Dr. Stolpner's counsel is correct that he would have been eligible for a physician's and surgeon's certificate if he had applied after his internship year. He did not. And what we have now is more and better information about his inability, or the concerns about his inability, to practice safely, which are brought forth after the scrutiny afforded by the grueling and close review of his clinical practice in a day-to-day setting in an ongoing residency program, rather 2 residency programs. At the first, Long Island College Hospital, he was placed on probation in his OBGYN residency program, quote, due to academic and clinical deficiencies. That program closed at the conclusion of Dr. Stolpner's first year, so that matter is inconclusive and left uncertain. More certain, however, is that from the situation at Lutheran Medical Center in New York, where he was restricted from patient care in 2015 after finding by the Clinical Competence Committee that he should not be promoted to the next year's postgraduate training level. Attempts were made to remediate his ability and level of skill, knowledge, and competence. Those were unavailing, and he was terminated from the program. He appealed that. A full hearing was held upon the appeal, and his appeal was denied. He remains terminated from the program. The 2 successive programs that found him deficient in his clinical abilities and knowledge are worth noting, and they are before the board, and they cannot, should not, must not be ignored. It is therefore incumbent on the board to ensure his safe practice by imposing reasonable and limited conditions on his license, if he's going to be given a probationary license at all, which should include, again, at a minimum, a 5-year period of probation with appropriate oversight by a practice monitor upon successful completion of a clinical education and assessment program such as PACE. This is the minimum required by the disciplinary guidelines. It should be the minimum that the board finds necessary to ensure safe practice if they believe Dr. Stolpner is an appropriate candidate with the potential to be a safe and competent practitioner as a physician in California. Thank you.
Thank you, Mr. Carr. Do any of the board members have any questions they would like to ask? No. I'm seeing heads shaking, so I'll assume not. And would Dr. Stolpner like to address the board directly?
Oh, I think I've spoken on his behalf unless the board has any questions.
Okay, I see that they appear not to, so this will conclude the arguments in this matter. The record is closed, the case is submitted, and we will be off the record at this time. And the panel will deliberate in closed session, so I'll ask that individuals clear the room. Thank you very much.
Thank you very much,
Thank you.
Judge Perlman, members of the panel.
Snow in Boston today, where she lives, and I'll tell her it's good for her. Hold it there.
Good morning. We are at the Medical Board Panel B meeting of April 19th, 2018, and we are going to open the session, and today presiding is Judge Perlman, and we will begin by taking roll call, please.
Ms. Lawson? Dr. Bolot?
Here.
Dr. Nonadev?
Here.
Dr. Kraus? Present. Dr. Levine?
Here.
Ms. Pines? Here. We have a quorum.
Thank you. I'd like to, again, Judge Perlman will open the session for us, and she'll be presiding over all matters.
Good morning, everyone. We're on the record. It is April 19th, 2018 at 9:32 a.m. We're in Los Angeles before the Medical Board of California in the matter of the remand of administrative mandate upholding the accusation against Syed K. Zaidi, hopefully I've pronounced that close to correctly, MD, Medical Board case number 02-2013-231663, OAH case number 2018-031-242. As indicated, my name is Lori Perlman. I'm an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over this hearing. We've established that there's a quorum, but for purposes of the record, I'll ask each of the panel members to identify themselves and spell their name for the record. So I'll start with Ms. Pines.
Denise Pines, Denise,
Dev Ganadev, DEV, Dev Ganadev, GNA, and DEV.
Sorry if you guys get the microphone, I'm sorry.
Oh,
Thank you.
trying to read at the same time, talk to you. Dev Ganadev, DEV, first name Ganadev, GNA, NADEV.
Hi, good morning. Michelle Bolot, Michelle, B as in boy, HOLAT.
Howard, Howard, Kraus, Krauss.
Sharon Levine, SHARON, LEVINE.
Thank you. Okay, so at this time, I'll take the appearance of counsel, and I'll start first with the Deputy Attorney General.
Good morning, Your Honor. Mara Faust, that's MARA-FAUST, Deputy Attorney General, appearing on behalf of complainant, the Medical Board.
Good morning, Ms. Faust. And for respondent?
Yes. Good morning. My name is Brad Wishek, W-I-S-H-E-K, appearing on behalf of the respondent, Dr. Zaidi.
So you might want to use the microphone closer to you because we can barely hear you. Thank you.
And then with you, you have respondent.
Syed Zaidi, it's S.
It's S-Y-E-D, Syed, last name Zaidi, Z-A-I-D-I.
Thank you very much. So the board in this matter is dealing with a remand to reconsider the level of discipline in this matter. And to that end, we will have oral argument. The process and time limitations will be the following. Respondent will have 15 minutes to make an opening argument. Complainant will have 15 minutes for a response. Respondent will have 5 minutes for a closing argument, and then complainant will have 5 minutes for closing as well. Is that the board's understanding?
Yes, Your Honor.
Okay. And these time limits will be strictly enforced, and the arguments must be based on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that would elicit new evidence. The ALJ and any panel member may ask a party to support the party's oral argument on a matter with a specific citation to the record. At the end of the oral arguments by counsel, I will offer the respondent physician an opportunity to address the panel regarding the penalty. If the respondent elects to address the panel, I'll place him under oath. After oral argument, the board will go into closed session to deliberate. The parties won't receive a decision today, but will be receiving it in the mail sometime in the near future. And with that, we will proceed to arguments, and we will begin, as I indicated, with respondent.
Thank you very much, Your Honor. Good morning, members of the board. Although it did not begin that way, this is now a very simple case. The board has found that Dr. Zaidi engaged in repeated acts of negligence with regard to 2 patients. And the basis for that finding is that he had failed in 2 patient examinations to adequately protect the modesty of those patients. The facts that support those causes for discipline are set out succinctly in the board's decision. With regard to the patient with the initials RG, the relevant finding is in paragraph 82 of the decision, which states in pertinent part that Dr. Zaidi then told RG to stand up and turn around. She was wearing a cloth gown and drape. She had just had a breast and pelvic examination and was naked under the gown. While respondent was performing a skin inspection, RG felt uncovered, naked, and exposed, and respondent provided little to no explanation for what was happening. For RG, she was standing nearly naked before respondent for no reason. The second patient is JER. And with regard to patient JER, the board's findings are stated in paragraph 84. And the relevant portion of that paragraph states as follows. JER was in nothing but a vest and drape when respondent was standing in front of her, pushing and pulling her legs closed and then open, exposing her naked vaginal area to him. Following the musculoskeletal examination, M.A. Eichenberg left the room, and respondent asked JER to stand and turn slowly around while respondent completed an examination of her skin. With only a vest to the waist and a drape to cover her lower half, JER was functionally naked before respondent. As JER turned, she exposed more of herself. Undoubtedly, respondent moved the vest and drape, as is his custom and practice, to view different areas of JER's skin, which left JER even more exposed. Finally, summarizing the violation, in paragraph 91, the board found, in the case of RG and JER, respondent's conduct fell below the standard of care. His behavior was incorrect. In addition, respondent seemed oblivious to the patient's perspective, but not devious or intentional. As such, respondent's behaviors can be corrected with proper counseling and education. The board's disciplinary guidelines with respect to repeated acts of negligence suggest that the minimum discipline would be 5 years of probation, but in the case of a single patient, suggests that in appropriate cases a public reprimand can be adequate. In this case, we provided to the board a summary in Exhibit E of respondents' evidence that sets forth for 2 quarters public reprimands that the board has deemed sufficient in order to protect public safety where there were 2 or 3 patients. Now, Ms. Faust in her argument had suggested that we had somehow tried to cherry pick or pick out particular decisions, but I would really disagree. All that we're really trying to do is to suggest this board has to make the decision in every case on the unique facts and circumstances what is necessary to protect public safety. Those decisions were provided as an example simply to say that the board has found it recently appropriate on certain fact situations, even when there are 2 or 3 patients involved, that it's adequate to protect public safety in repeated acts of negligence cases where there are 2 or 3 patients. And I would say that this is exactly that kind of a case. In the board's words and the findings, the errors that were committed by Dr. Zadie can be corrected with proper counseling and education. And the record in this case is very clear that Dr. Zadie began making changes in his practices, taking steps to learn about how to better interact and communicate with patients immediately after the complaints that were made by RG and JER back in the year 2013. And he has continued diligently that education, and more recently in the past year on probation, psychotherapy, counseling, to cure this knowledge deficit. Dr. Ty Arnett was one of the witnesses who testified at the hearing. And he was the physician who supervised Dr. Zadie for the last year that Dr. Zadie worked at the University of California at Davis at the Carmichael Clinic. And he specifically was asked and testified that Dr. Zadie is a good doctor. But Dr. Zadie had some deficits in his view with regard to his communication style and how he interacted with patients. And these are the questions and answers that he gave on that subject, and this is his testimony from April 7 of 2016 at page 48. Question: can you describe for us your assessment of Dr. Zadie's demeanor when he was with patients? Answer: I thought he was a bit stiff, if you will. Question: and would you describe him as being personal with patients? Answer: personable, but maybe not personal. Question: what does that mean? Can you explain it to us? Answer: that means very professional in spoken and written action, but not really getting into the story with the patient so that you break down barriers. Patients are very nervous when they come to see a physician, and you can sense that if you know the patient. And so part of what we try to do is break down those barriers so that you can really find out, really assess, is there something else going on? You know, what am I missing? Now, Dr. Zadie testified that he began to make significant changes in how he interacted with patients because of his extreme concern at the complaints that had been made by patients RG and JER. And the record reflects that patient RG he had actually seen at a prior clinic just a couple months before, and he had seen patient JER very shortly after he arrived at the Carmichael Clinic. In paragraph 80 of the board's decision, this change in his practice is acknowledged. The board said that he testified that he changed his behavior after he was informed of RG's and JER's complaints about his full skin examinations. Thereafter, a respondent modified his practice and did not stay in an examination room alone with a gowned female and asked patients whether they wanted a full skin examination as part of their physical. During the course of the hearing, we presented testimony from two of the medical assistants that worked with Dr. Zadie in the approximate year that occurred between when these complaints, or I'll say when he saw the patients, and when he left the Carmichael Clinic. The first of those two medical assistants was Shannon Hartman. And Ms. Hartman had testified on April 7th of 2016, and she was asked these questions and answers beginning at page 132 of the transcript. Was there ever a time where there was a patient that was dressed in their street clothes and that Dr. Zadie needed to look at part of their body, and he would have you come and chaperone those examinations as well? Yes. What kinds of things would Dr. Zadie ask you to chaperone when the patient was in a gown and was in their street clothes? Answer, he would buzz the light, and in the room there is these little buttons that you press. It chimes into the nurse station. So if I was available or someone else was available, we would come immediately to the room because it flashes. We would go to the room, we would turn the light off, and depending on, what it is, he would say, show me the spot. Some patients would show like their upper arm. They would pull their sleeves up so their arms, or if it's their shoulder, their shoulder. Sometimes it was their legs or their pant legs, and he would have them pull up their pant legs. When you worked with Dr. Zadie, did you think that he respected patients' modesty? Answer, yes. And did he explain to patients what he was doing and what the purpose of his exam was when you worked with him? Always. How would you describe Dr. Zadie as a doctor? Answer, I thought he was a wonderful doctor, and I was very proud to work with him. I think his patients were very proud to have him as his doctor. They continue to tell me that. I see them often. And he was very respectful and, very much a patient advocate, always trying to make sure they did their labs and kept them on things that they weren't keeping up with for themselves. The other medical assistant who worked with Dr. Zadie during that period of time was Linda Cattell, and she also testified on April 7th of 2016.
Could you spell her name for the record, please?
Yes, Kittel.
Thank you.
Beginning at page 159 of the transcript, she was asked, when you described Dr. Zadie having to come in to look at a patient's arm, were they in street clothes? Yes. I saw them in both ways, both in street clothes and in gowns, yes. Did you have an opinion that Dr. Zadie used chaperones more than any other doctors? Answer, again, for things like normal women types of exams, those things, no. That is a standard practice. I expected that. For things like the different kinds of skin types of checks, yes. Then, yeah, there were much more than the other doctors. Okay, was Dr. Zadie kind of, I don't want to say famous, but did staff talk about Dr. Zadie being more needy of medical assistants and chaperones than other doctors? Answer, I don't know that I would necessarily call it needy, but I think I would probably characterize for myself, it seemed unusual that we would go in for those different kinds of things because it wasn't typical. It was atypical behavior. And so the record is very clear that from the time that these complaints were made, Dr. Zadie began working hard to ensure that he had someone with him during a skin exam, even if the person was not in a gown and a vest, to ensure the patient's modesty. And we also have, from that medical assistant, her perception of how thoughtful he was in how he had began to communicate with his patients in the year that followed the time that he had seen RG and JER.
You have 3 minutes.
Thank you. Dr. Zadie has continued those efforts. As you know, in the record, Exhibit B, Dr. Zadie went to a PACE physician communication course even before the hearing in this case. Dr. Zadie testified at length, and there were exhibits that were presented regarding the books, articles, and things that he was doing to work hard to understand how to better communicate with his patients. Dr. Zadie, in this case, provided to you a short video that explains the concern that he has for these patients, what he has learned from this case, and what he has been doing over the course of the last year to ensure that he is fit to practice and that he has learned from this mistake. You also know that he's been seeing Dr. Greenberg, which was a condition of his probation, and Dr. Greenberg, in the declaration that has been submitted, says the following. Dr. Zadie has taken this process very seriously. Dr. Zadie has kept every scheduled appointment and has never been late. He has been completely compliant with all aspects of treatment. In particular, Dr. Zadie has been extremely open and forthcoming in discussing the underlying facts and his current situation. He has never been defensive or evasive. He acknowledges his shortcomings and has been eager to explore and learn from them. Dr. Zadie has demonstrated insight into his behavior and has used our time together to work on improving his communication skills and empathy. Dr. Zadie has expressed genuine concern for the patients who filed complaints against him. Although he disputes some of the conclusions about him, he has always acknowledged the legitimacy of the feelings, concerns, and consequences experienced by his patients, and in fact, has shown more genuine concern for them than for himself.
Your time is up.
Thank you.
Did you want to say one more sentence?
Yes, thank you. This is a good doctor and a man who has taken to heart these lessons, and a public reprimand is adequate to protect the public.
Thank you, Mr. Wishick. Okay, I turn to the Deputy Attorney General now, and you have 15 minutes.
Thank you. Good morning, members of the board. This hearing is a remand to reconsider penalty. Originally, the judge also found that there were inaccurate records in that the respondent said there were chaperones present for these two patients when there weren't. What the judge also said, though, was he didn't intentionally make the record inaccurate. And you need intent for it to be a deceptive record, and that's why the judge struck those counts. So we have this inconsistent ruling, no chaperones, but he didn't intend to mislead in his record. So the remand now is to say, what's the penalty on these repeated negligent acts for the nearly naked skin exams, but without the issue of the record keeping? Now, JER came in to see Dr. Zadie for peeling skin on her toe, and the next thing she knew, she had to wear a paper vest and it was a paper vest and paper towel, and he would not let her keep her underwear on. In that getup, he did expose her vagina to his view, and she was very uncomfortable with that exam, given she came in for a peeling toe. RG came in for a well woman exam. The next thing she knew, she was down to, again, a vest and paper blanket. She did have a breast exam, but she was asked to stand up and turn around in a nearly naked fashion. She said she was naked. The husband said she was holding a blanket. The judge said she was naked under a gown. In any event, the question is, why was that, given it was a well woman exam? As the court has instructed you, you need to look at only existing evidence. Respondent has attempted to supplement this record wildly with exhibits A through E. Let's first go with the exhibit that you can consider fully, which is Exhibit A. You're allowed, the only supplementation really you can consider is what is the respondent's attitude and what has he done in the interim in terms of compliance with probation. So Exhibit A is his declaration as to what's happened in the interim, and that's fair game. You can look at that. However, what he says is, while he's enrolled in PACE, he hasn't done PACE because of this 4-month extension, and he then mischaracterizes that 4-month extension. Now, perhaps he's confused. The 4-month extension was either from the board's denying from the Superior Court denying the petition. This is an email that's attached to his declaration. Commencement of the judgment of the Superior Court denying the petition, or the effective date of the board's decision after remand, whichever occurs first. So what occurred, the petition was denied in part on November 3rd, 2017. Technically, that means the 120 days ran March 3rd, 2018. So that begs the question, why hasn't he done and completed PACE, given that the first event is the ruling on the petition? And, you know, we'll hear from him, presumably, in his response on that. But that's an issue. He has not done PACE. He's enrolled, but hasn't completed. As to the other attachments, there are two groups. Exhibit D and E, you can't consider at all. This is an attempt to supplement the record. It's not relevant, and you basically need to exclude it, and I'm going to move at this point that you exclude Exhibits D and E. Exhibit D is the declaration from Dr. DuPont, who was respondent's expert at hearing. Clearly, the ALJ did not go fully with Dr. DuPont's opinion since she found violations, and he said there were none. He does not now get to recharacterize, gee, they didn't ask me X, Y, and Z at hearing. The hearing record is closed. He doesn't get to opine now. And he exhibited bias at the hearing because he also counseled Dr. Zaidi on communication issues and yelled at him, had counseling sessions, not the normal role of an unbiased expert who's merely reviewing the record. All of his statements in that new declaration have nothing to do with what occurred at the hearing. Exhibit E.
Dr. Pont's name for the record, please.
Oh, Dr. It's, okay, so his spelling, let me just.
I've got it here, actually.
Allen, A-L-L-A-N, Pont, P-O-N-T. That's Exhibit D. Exhibit E, which talks about other PLRs, there's actually case law that allows you to exclude it, not just did he or didn't he cherry pick other cases where a public letter of reprimand was found. It's the case of, and I'm going to misspell this, Pigues, P-E-G-U-E-S, the Civil Service Commissioner, or Commission, 1998 at 67 Cal App 4th 95. With penalty, there's no requirement for an agency to consider similar penalty for similar misconduct. And in fact, you do not need to, the penalties don't need to correlate. And of course, in this case, as we pointed out earlier, the facts on these other cases don't relate, as to 2 of the 5 relate to female physicians having to do with OBGYN issues, and the other PLRs have to do with overprescribing. None of them have to do with a failure to maintain modesty in skin exams on female patients. So again, we would move to exclude Exhibit E as well on other penalties and other contexts. Now, as to Exhibits B and C, we would move to exclude in part. Exhibit B, it's fair to see what Dr. Zaidi has to say about his attitude today. That's the first third of that CD video. But the back 2/3 are his wife attempting to improperly supplement what didn't happen at the hearing. She initially complained in a criminal context about his conduct and then took the spousal privilege and refused to testify at hearing. She does not now get to raise new issues after the fact as to his character when she refused to participate and protect him at the hearing. So I would ask that you exclude and not consider anything that his wife has to say in Exhibit B. Exhibit C is Mr. Greenberg, PhD's declaration. He is not a doctor, he's a PhD, and we actually have a statute that says we don't necessarily refer to PhDs as doctors in formal hearings. And he can testify about his view of Dr. Zaidi's therapy. That's fair game. He cannot testify about the psychiatric evaluation that occurred in this case because he's not a psychiatrist. He cannot testify about the need or ability of PACE to cause rehabilitation. as he is not a psychiatrist. We would move to strike paragraphs 8 through 11 of his declaration and caution the board to, I know that in respondents' briefings they refer to him as Dr. Greenberg. He is a PhD. So, with respect to the record and some of the other comments, I would just like to point out that Dr. Arnott, who Respondents' Counsel pointed out, testified at the hearing, was supervised by Dr. Slapnick, Kurt Slapnick.
Could you spell both of those names for the record?
Okay. Arnott or Arnett, I may be wrong. I may need help from co-counsel. I think it's A-R-N-O-T-T? Okay. And Dr. Slapnick is S-L-A-P-N-I-K. Under our further recommendation for remand, we cite that in his interviews with Dr. Zaidi, he had the impression that these skin exams were full-on naked skin exams and that he was counseling Dr. Zaidi on how to do them more properly, just exposure bit by bit. And that's, his testimony is on page 4 and 5 of my supplemental further recommendation. And the court seems to have disregarded that testimony because she didn't find that they were full naked skin exams, despite UC Davis finding that they were full naked skin exams. In addition, while we have testimony from third-party chaperones later saying they're always there, we had the chaperone M.A. Eichenberg, E-I-C-H-E-N-B-E-R-G, who was present for part of JER's exam, but that she was told to leave and that Dr. Zaidi spent some additional time with the patient when she was naked under basically the vest and drape, the blanket, and there was some time when they were there alone without a chaperone. And again, that testimony is also included. I'm not going to cite it again under the further recommendation for remand. Now, the other things to consider are that in the last 2 years, even though Dr. Zaidi has been otherwise compliant with probation, he has not been practicing. So we do not have any clinical picture of him since these events. And he has not passed PACE. So the real issue is he essentially trustworthy with female patients at this point in time, and what do our disciplinary guidelines require? The ALJ on these 2 negligent acts felt that 5 years probation was appropriate. Probation is still appropriate on these repeated negligent acts under the disciplinary guidelines. If the board feels that because the dishonest record keeping is gone, that discounts the period of probation, you can appropriately consider 3 years as opposed to 5 years. But it's also well within your power to still assert a 5-year probationary period. That's up to you within your discretion. Given that he hasn't practiced, given that he hasn't completed PACE, given the nature of the conduct and his lack of sensitivity to these patients, I would argue probation is the only appropriate discipline here. I think that's all I have, unless there are questions. That's our position.
Okay, thank you. I think we'll hold the questions until we complete the oral argument, unless the board prefers otherwise. Okay, they're okay with that? All right. So I will turn things back to respondent at this time, and you'll have 5 minutes.
Thank you very much, Your Honor. With regard to the testimony by Dr. Slapnick, as Ms. Faust points out, the judge rejected that and found that the patients were gowned and draped. It may be because in his testimony, which took place on June 6 of 2016, at page 37 of the transcript, What he said when he was finally asked, is it possible you were mistaken in what you understood that Dr. Zadie had said? His answer was, it's possible. And Dr. Ty Arnott was present at that meeting and testified that he never heard Dr. Zadie say that the patients were naked when the skin examinations took place. With regard to what's been characterized as new evidence, what we are calling the evidence on remand, there has been no citation that has been provided to the board to suggest that that evidence should not or would not be considered by the board with regard to the motion to exclude it. We provided the board with a citation to the Court of Appeal decision in Toyota of Visalia, Inc., the New Motor Vehicle Board, and in that case, this is what the court said, verbatim. Evidence of good behavior, good practices, and lack of dereliction, as well as other evidence relevant to the issue of penalty, is properly admitted at the hearing on penalty, even though a long period of time has transpired between the findings of violations and the hearing on the penalty. There is no question that each and every one of the exhibits that have been submitted by Dr. Zadie goes to the appropriate penalty that should be imposed in this case and goes to his attitude toward and hard work to remediate the knowledge deficits that he had. And for that reason, and under this authority and no other authority has been provided to the board, all of that evidence is admissible and should be given the weight that each of the board members believe that it is entitled. I want to be clear. I'm not suggesting that there are similar facts. Anytime you have a deviation from the standard of care, each and every circumstance is going to be different. And those earlier cases that were offered were only to suggest that similar to the guidelines that the board uses, the board has recently seen some 2 and 3 patient cases that are appropriate. It is entirely within this board's determination and discretion whether this is that kind of a case. The last thing I simply want to address is I'm a little stunned by the suggestion that Dr. Zadie has not complied with the PACE program. The email is before the board. The agreement was when the writ is rejected or there is a decision after remand. Here, we had a hybrid, which may not have been anticipated by counsel, which is that the writ was granted in part and it was denied in part. And the whole purpose now is for the board to reconsider what the appropriate penalty should be, and that is why it is appropriate for him to wait until after the remand. The writ was granted in part, and it's come back for remand. And for that reason, it's appropriate for Dr. Zadie to await this board's decision. He has done every single thing, and then much more than what the board ordered. The additional CME that he has done is about twice what he was required to do under the board's order. He has complied with every condition, and he has done so in an open and honest and thoughtful way, as is reflected by the declaration of Dr. Greenberg. And so for those reasons, I feel very strongly that this is a case that is appropriate for you to issue a public reprimand, but to require Dr. Zadie to do one of the PACE courses that was recommended or ordered in the original order, and that is the PACE course that relates to physician and patient boundaries.
Sorry, physician and patient?
Boundaries.
Boundaries. Thank you.
Thank you.
And your time's up. Thank you so much. And back to the deputy for 5 minutes.
Okay. The board also needs to deny respondent's motion for a further hearing. He's asked in his papers that this go back to the ALJ to hear a variety of issues, and that is beyond the scope of the Superior Court remand order. The Superior Court remand order says this has come back here merely to reconsider penalty on the existing record. And so the board needs to be very clear that's all they're going to do. We're not going to go back and do new hearing time. And so again, we need to strike declarations D and E and parts of B and C and determine this on the record. All of the conditions that are in the ALJ's original decision should remain in effect, and probation should be the imposed penalty. Thank you.
Thank you very much. Did the board have any questions? Yes, I see we have one. Would you identify yourself for the record?
Howard Krause. Does Dr. Zaidi wish to address the board directly?
Yes, sir.
Can I?
So let me go ahead and swear you in then at this time.
Sure.
If you'll raise your right hand, do you solemnly swear or affirm under penalty of perjury that the testimony you give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. You can begin when you're ready.
Can I sit down?
Yes, absolutely.
Okay. Thank you very much for giving me the opportunity again. I was before the panel over a year ago. I believe it was January 2017. My probation started in March of 2017. Many things have happened since then. I wanted to update the panel about that. But first I want to apologize to these patients. I did that in my first appearance to the board as well, and I want to do that again. These patients, what they've gone through was distressing, was painful when they saw me as their physician, and I'm sorry for that. I want to convey to these patients, their families, and to the board that I have done every possible avenue, I've taken every possible avenue, I've done everything possible to basically, do something about this shortcoming, this problem that I had in terms of how I was interacting with the patients. It could be the CME, it could be the courses, the books, and then certainly for the last year, Dr. Greenberg has been a very helpful source. My therapy has primarily focused on different things that, that can help making the interaction as a, something that the patient can actually start trusting the physician. It could be the active listening. It could be small things like how you meet and greet the patient. It could be your body language. It could be your eye contact. And certainly I've worked on the skills of empathy and mindfulness. I have been a stay-home dad for the last 3 years, and that was a kind of an opportunity to spend more time with my kids. I have 4 kids, and certainly I applied the theory of empathy and mindfulness to them as well while I was interacting with them, and I can tell you that it has created a bond that I've never thought that it could exist. My wife sometimes feels jealous about that. I have been, one more thing that I want to talk about is I've been back and forth to Pakistan because my parents have been sick, and my father was diagnosed with esophageal cancer. My mother had a stroke. This was all happening back and forth. The point I'm making, that was the time that I first felt how does it feel like when you are sitting opposite the doctor. And my father was actually refused by 2 or 3 oncologists initially that they are not going to treat him. And I can tell you that experience was horrible, the feeling of helplessness that comes. And so this was a first-hand experience. I had discussions with Dr. Greenberg about this, and that has actually, given me more confidence in terms of the mindfulness, how you basically think what the patient is thinking. I have done everything in terms of making sure that this would never ever happen again. I'm absolutely receptive to whatever decision you guys make. If you have any questions, I'll be happy to answer. Thank you.
Thank you. Did the board have any additional questions? I'm seeing they do not. So at this time, we have completed the argument phase of our matter, and I will close the record at this time. The case will be submitted, and I thank everyone. We will deliberate in closed session, so we'll have everyone clear the room, and we're off the record.